Richard Nixon is not just the only American president to resign. He went to his grave never knowing of the prosecutor's secret allegations that destroyed his presidency. This is Watergate Revisited, an insider's view. Good day to you. I'm Jeff Shepard, and I'm your instructor in a course called Watergate Revisited, an insider's view. This is the 11th of 12 weeks of presentations on Watergate from an insider. I'm the insider, so these are my views. I was there. I lived through it. I was on Nixon's White House staff for 5 years, and I functioned as deputy counsel to the president during the Watergate defense. So for the last 10 months, I was full-time on the Watergate defense. If you lived through it or you watched it on TV, you know it ended rather badly. I lost my first case, but I've recovered. I don't tell many people about that loss, but I'm telling you. And what we're going to talk about today, we're going to hit with a sledgehammer what I think are the judicial and prosecutorial abuses that characterize the Watergate cover-up trial. I understand the people were convicted, but you need to understand lawyers don't play fair. They argue two things. They can argue, look, the person didn't do the crime, the person wasn't guilty, but usually in a political scandal, the argument is there wasn't enough proof to find them guilty beyond a reasonable doubt. Very high standard. It's not they were blameless. It's not they were innocent. But we say we'd rather let 100 guilty go free than convict one innocent man. So we're loading it to a very high standard. The other thing that lawyers argue, which the public sometimes has trouble with, is procedure. If you didn't get that evidence into the courtroom properly, then it can't come in. If you didn't share exculpatory information properly with defense, those are procedural violations which can equally invalidate a verdict. And I'm happy to argue both. So that's kind of what we're going to go through. One word from last week. Last week was the allure of the White House tapes. And I went through a bunch of them with you, perhaps too fast. What I find fascinating about this, because I transcribed them, I worked word for word for hours in tracing what they were saying and the points they were trying to make, trying to understand to get the transcript right. And I give you that example of Nixon telling John Mitchell to stonewall it, plead the fifth, if it'll save it, save the plan. And I said, that's not what he's saying. He's sending his best friend out to walk the plank. He's making him go in front of a grand jury without claim of executive privilege. And he's trying in his own way to say, look, I don't care what you say when you go, but you have to go. So he says, I don't care if he's talking about the others, but he means John Mitchell, they can stonewall it, plead the fifth, cover up if it'll save it for them. And if properly understood, it would have been a very noble speech. And then it's followed by the paragraph that says, I'd rather the truth come out because it's going to be worse by leaks. So it would be better if everybody just tells the truth. But it's totally misunderstood and mistranscribed to suggest the opposite. Same thing with his going away speech the morning of his resignation. Calls his staff together, the White House staff, who've all been on the long march, and he says goodbye. And his family's up there, and I, of course, because I, at the time, was amongst those that misunderstood the smoking gun. I thought he made his family come stand there with him. I thought it was terribly, terribly cruel. But it turns out they demanded to be there. They were with him to the end. And then he tries to explain to the staff. He says, if you hate your enemies, they win. You just can't do that. And everybody said, oh, what a maudlin speech. What a crazy thing for him to say. But this is his Quaker upbringing. This is what his mother's taught him. And he really means it. He really means if you hate your enemies, if you're consumed by hatred, then you lose. And you should be able to rise above that. And then thirdly, and I don't think I hit this out of the park either, he keeps talking about Alger Hiss and his takedown of Hiss at the beginning of his career. And there are at least 18 references on the tapes to Alger Hiss. And what he means, people don't understand what he's saying. He's saying Hiss perjured himself under oath. That's why he was in such trouble. The statute had run on being a commie. That wasn't, but where I nailed him was perjury. So I submit to you, if anybody had asked Nixon, it shows up on the tapes, should we go down and lie trying to cover up this Watergate break-in, he would say, heck no. Then you've doubled your problems. You got the problem of the offense, and then you've got the problem of perjury. Why on earth would you ever do that? But people they aren't willing to give Dick the benefit of the doubt. They think the references to Hiss are a mano a mano combat between two gladiators, and he doesn't mean that at all. That's enough for the tapes. Let's go, and we will talk about special prosecutors, and we'll go back to our good friend Renata Adler, who's a very liberal journalist who was on the House impeachment staff, and then she went to law school, and she wrote a bunch of stuff. And this is her comment on the special prosecutors. Office of Special Prosecutor, true conservatives said this from the first, had always been a constitutional abomination. To begin with, it impermissibly straddled the three branches of government. If Nixon had not been in such dire straits, he would never have permitted such an office in the person of Archie Cox. The press, however, loves special prosecutors. They can generate stories for each other. That something did not happen is not a story. That something does not matter is not a story. That an anecdote or an accusation is unfounded is not a story. There is this further commonality of interest. Leaks, anonymous sources, informers, agents, rumor mongers appear to offer stories and the good possibility for offers, pressures, threats, and rewards. The journalists exchange an attractive portrayal for a good story. There we are. The reporter and the prosecutor, the special prosecutor, not as often the genuine prosecutor, are in each other's pocket. I mean, and this is, I've been trying very hard to quote from liberal people. It's not the bitter friends of Jeff Shepard. It's liberals at the time or shortly thereafter who are complaining about how this was handled. The next one gets better. There's this guy, the legal commentator named Richard Harris, who wrote for the New Yorker. He's their legal commentator. And in June of 1974, that's after the indictments, before Nixon's resignation in the cover-up trial. So this is starting to roll. We know there's going to be a trial, but it hasn't occurred. He says the only way to punish corruption in the Nixon administration was by bringing the Watergate criminals to justice. This is being done to an extent. But to restore public confidence in our democratic system fully, it was also essential that the prosecutions be conducted fairly. That has not been done. In fact, many legal practices employed by the prosecutors to reestablish the primacy of the law in this nation appear at this stage to have perilously subverted it. In the end, history may conclude that the way in which those guilty of crimes in the Watergate affair were brought to justice did more lasting damage to the highest purpose of American law than did the crimes themselves. Now, there's two more on this. Harris I like, okay? I'm quoting him further, same article. The use of generally discredited and unenforced laws in order to get someone who has probably or even certainly broken other laws but cannot be successfully prosecuted for those crimes. The use of grand juries, which were originally set up to protect the innocent, as investigative aids to the prosecution rather than accusatory bodies. The use of plea bargaining, in which a prosecutor offers a defendant a lesser charge in exchange for either a guilty plea or information about crimes committed by others. The use of partial or total immunity from prosecution in exchange for information. The use of selective prosecution, in which one person is tried for a crime, although others who are equally guilty of the same crime are ignored. The use of conspiracy charges, when evidence of the crime that is believed to have been committed is flimsy. The use of perjury charges for the same purpose. The use of criminal sanctions that can be applied against ordinary citizens, but not against government officials. And the unequal application of the law in general. And he goes on, because we're going to go to the next slide, say this is what they've been doing. Okay? This is his talk about public perceptions. Once a large majority finally became convinced that serious wrongdoings had indeed intentionally been committed by some of the nation's highest officials, probably including the president, public demand for cleaning up the wreckage and punishing those who had caused it grew irresistibly. Pressed by this demand and persuaded that there was an urgent need to meet it swiftly, the prosecutors, with an astonishing disregard for fairness, fell back on all the means that could reasonably be justified by the end, including use of some of the same legal practices that had been so freely and perniciously employed by the Nixon administration and so roundly condemned by its critics. So we're going to get to a slide that says, how come we didn't know this stuff before? How come we're hearing it from Shepard from the first time? This stuff was out and around, being said but got no coverage. I mean, the New Yorker is a liberal publication. This is a prestigious guy dumping all over the prosecution, but no coverage, no further coverage. Okay, I have complained to you for 11 weeks that Judge Sirica met privately, secretly, with prosecutors and with people with interests adverse to Richard Nixon's. And I have him in the center of the bullseye, and I have 6 guys around the side. We're going to talk about 3 of them, so I have more time to go into the specific things. And we're going to start with the guy in the lower right corner at 4 o'clock, Clark Molinoff, whom you don't know. He was a reporter for the Des Moines Register, graduate of Duke Law School. He was a licensed attorney in the district the whole time. He was a confidant of Judge Sirica. He'd known him for years. He was also ombudsman to President Nixon. When Nixon got elected, Clark went to him and said, you know, what you need is a whistleblower on your staff, an ombudsman, to warn you if your staff is not doing something the right way. And I can think of a perfect candidate. I don't like you, but I could keep you out of trouble if you'd hire me. So Nixon goes for it and hires this guy, you know, a viper to his breast. And he wanted to report directly to Nixon, but he ends up reporting to the counsel's office, John Ehrlichman. And he has the title of special counsel because he's a lawyer. And he stays for 10 months and then he leaves in disgust because he didn't have enough access to Nixon. And he would say, well, you know, I want to discuss my issues directly with the president. And Haldeman or Ehrlichman will say, well, we've discussed it and this is the president's decision. And Clark would say, well, how do I know unless I hear it from the president? And maybe the president didn't hear my point of view, so maybe his decision as relayed by you is wrong. And that went down really well. So after 10 months, he leaves. But he leaves with the credibility of having worked on the Nixon White House staff for the previous 10 months. He heads up the Washington office of the Des Moines Register and becomes the dean of the Washington-based investigative reporters. This is before Woodward and Bernstein. They were, you know, a glint in someone's eye. But Clark Molinoff was big stuff. He's written a whole bunch of books, but 2 of them had to do with Watergate. One, I have a picture here. Here's a picture of Clark, Nixon in the Oval Office. Nixon's got his feet up on the desk. This is what blew the tapes, you know, when his feet clumped down on the desk. And supposedly he's listening to Clark. Clark appears to be left-handed. Well, I always look for that. I'm left-handed. Well, I look for people who are left-handed. So these are 2 books. I'm going to quote from the later book. He wrote a book about investigative reporting because he was the expert. the expert muckraker, the expert village scold. Nothing ever quite met Clark's standard for propriety. The White House game plan was apparent to me. There would be the addition of some minor figures with White House connections indicted to give the impression of an investigation. But even those indictments would be part of an obstruction of justice unless they included Magruder, Haldeman, and Stans. Maurice Stans is finance chairman for the re-election committee. And he had this interview with Stans. As a result of the Stans interview that occurs September 14th, the day before the burglary indictments come down. Okay, this is early on. Because of the Stans interview, I knew Richard Nixon was involved in planning and directing a cover-up that was being executed by John Dean in the White House. So he's saying in his book, the interview was embargoed, so he couldn't print it, he couldn't tell anybody. But he knew from that interview, there's a cover-up, Nixon's at the heart of it, John Dean's running it, okay? Who can he tell? Well, one of his best friends is Judge Sirica. And Judge Sirica has just appointed himself to be trial judge for the break-in trial. And he even says in his book, this later book I'm going to quote, that he invited Sirica down to have lunch in the White House mess when he was special counsel to Nixon. Because, they were close and it impressed the daylights out of Sirica, because Clark was an insider in the Nixon White House. So he goes to meet with Judge Sirica, and this is the second book, okay? It comes out first. I hesitated to write or speak of my conviction that Sirica would be trustworthy and aggressive as a judge. This reluctance endured despite long conversations with him in the fall of 1972, in which we talked of the importance of honest government, and I expressed a belief in the eventual triumph of right over wrong. We did not speak of the merits of the cases. Oh, of course not, Clark. But I was sure he was lonely and in need of assurance that if he did precisely what he believed to be right, at least one individual were to remember it and record it in historic perspective. So he's sitting there lobbying Sirica in secret. And I tell you, I'm making this up, okay, but I know what he was doing. Judge, you're the only person that stands between this cover-up being successful and the truth coming out. You've got to use the trial is in the pursuit of truth. That's the purpose here. And you do that, and I will write columns complimenting you on what you're doing because I'm so influential. Long conversations with him in the fall of 1972. I don't care how good a friend you are with the judge, you don't sit down with a judge and tell him how you think he should conduct the trial. Okay? You just don't do that. This comes out, no one seems to care, because Sirica was meeting with everybody. So we go back. You saw the slide a moment ago, but you didn't see number 7 down there at the bottom. Turns out, fired from register for improper conduct, 1977. You remember when we were talking about triggering IRS audits and John Dean had 17 people, he's going to go bag them. When that came out, it turned out another thing that was happening was the White House was asking to see IRS returns on particular individuals. And it turned out they were being requested by the counsel's office. And it turned out the individual in the counsel's office that was asking to see these IRS returns, these tax returns, your tax returns, Trump's tax returns, was Clark Molinoff. And there was a story about it. This is long, this is 3 years later, who cares? So it turns out the president of the Des Moines Register said, that's strange. And he did some checking and he found out which returns were requested. Okay? And he found out they were returns by people Clark didn't like, that he'd written articles about, or that the Des Moines, Washington Bureau was writing articles about. So what you have, this village scold, this great hero of investigative reporting, when he was in power, immediate abuse. And they fired him for it. They didn't make a big public thing out of it. I uncovered this because the guy wrote a book and said, about being head of the Des Moines Register. And he had this line in there that said, I fired a Pulitzer Prize winning reporter. And I only knew of one. And so I sent him an email. He sends back, he says, oh, you're writing a book. And I said, yeah, but it's not really about Clark. It's about this other stuff. But this sounds really intriguing. And he sends me an email and describes the whole thing. He said, here's what I remember. I came and checked, and he'd pulled all these IRS returns without authority to further personal grievances. Just illegal as hell. Okay, we go on. This is from Sirica's own book, and he describes his meeting with Earl Silbert. Earl Silbert's the first prosecutor. Earl's 10 years of prosecution experience. Sirica's approaching 70, so Earl's young, but Earl's hardly green behind the ears. He's the principal assistant U.S. attorney in the District of Columbia. I like Earl. I think he's a good lawyer. I wanted to be helpful, to share with him some of my experiences, which I felt might give him some guidance through what was obviously a tough situation. A few days before the trial started, this is the burglary trial. He was in my chambers discussing something else, and I said to him, Earl, look, you got a great opportunity in this case if you go right down the middle. Let the chips fall where they may. Don't let anybody put pressure on you. Before he left my office, I gave him a bound copy of the hearings conducted back in '44 by a select committee of the House into the activities of the Federal Communications Commission. I wanted the young prosecutor to know just how whitewashers were engineered, and I wanted him to know that I had direct experience with cover-ups while serving as chief counsel to that committee. This is the judge telling the prosecutor how to put on the case. He doesn't say it here. This is the judge's version. It's Earl, go after the truth. Don't let them confine it to the burglary. Use the trial to figure out who at the White House was involved. That's what I want you to do. That's going right down the middle. There are, in the Library of Congress under Judge Sirica, in his files, 6 earlier versions of the book. There wasn't a ghostwriter. He really wrote the book himself. And you can trace the significance. It starts getting reduced because his editors are saying we don't need to know that. But this was huge because Sirica was counsel to this committee, and they were going to go from public hearings to executive session. And Sirica said, that's a cover-up. If you do that, I'll have to leave. And they did it, and he resigned. No, he wasn't. He was retained for the committee. He was in private practice. But he felt this was among the most significant things in his life, that he wanted the truth to come out at the hearings, and he wants the truth to come out at the burglary trial. Now, what makes the burglary trial so unique, they were caught red-handed. Nobody really cared why they were there. That wasn't the issue at the trial. And Earl, and I read this to you, Earl's memo to the head of the criminal division the day they came down with the indictments was we've traced as far as we can trace, we can prove these people. When we're through with the trial and they're looking at a long prison sentence, we'll see if their story changes. But for now, we've got these guys cold. That's who we're taking to trial. And here you have Sirica saying, no, I have a higher purpose. And it corrupts the trial. Now we go to the next set of prosecutors. This is Jaworski, and start with a second dot. We're going to talk about 3 key meetings, December 14th, February 11th, and March 1st. And the reason we learn about these later is Jaworski took his files with him when he left, and he dictated memos. We're going to see the memos. There's that tantalizing Woodward interview. I've shown it to you 2 or 3 times, where he interviews Jaworski after he resigns, and Jaworski says there were lots of one-on-one meetings between me and another guy, and nobody knows about them. And then he says, we were staffing the House Judiciary Committee, and Woodward doesn't follow up on either one. So we didn't learn about these secret meetings until they became available to me in 2013. We'll start with the first one. This is a letter. I know you can't read it, but that's okay. This is a letter to Judge Sirica, And up in the upper left corner, not quite, right below the handwriting, it happened to be my handwriting, it says P-A-L. It's Phil Locavara. This means Phil drafted the letter and his secretary typed it. It's not a Jaworski letter. We're not even sure that Jaworski signed it because it's dated December 27th and he's in Texas. And you read the first line. It's in bigger print. When Messrs. Ruth Locavara Benvenisti and I met with you and Judge Gazelle at your request on Friday, December 14th. The 4 top Watergate prosecutors meeting with the 2 judges who are going to do the Watergate trials. What's going on? They can say anything they want. This isn't a casual hallway conversation. This is a formal sit-down. Jaworski's been special prosecutor for a month. Sirica calls him down. 3 days before this meeting, the meeting is December 14th, Sirica turned over to the prosecutors the transcript and tape of March 21st. That's the Cancer and the Presidency meeting. The books by the prosecutors say, wow, Nixon was tempted to pay blackmail. Dean goes in, we're being blackmailed. Nixon says, what the hell, $1 million? You know, why not? It's a dramatic moment in everybody's book. You can't tell me that isn't why he called them down. He wanted to know their reaction. Now, there's no legal reason for the meeting under any circumstances, but the timing is highly suspect. This letter appears to be a CYA letter. It's written 2 weeks later, and near as I can tell, Jaworski and St. Clair had talked the morning of this letter. And I think Jaworski became concerned that the knowledge of this meeting would come out. And I think this is a fake purpose. The letter, if you have the whole thing, doesn't make any sense. It says we're going to predict what cases are coming down the line, but you can't tell from the description what the cases are, except for one statement. I believe by the end of January or the beginning of February, we may have an indictment in a case that could take 3 months. That's the cover-up trial. And he's saying, we'll have the indictment for you end of January, beginning of February. This is terribly important because Sirica is going to turn 70 on March 19th, and he will have to step down as chief judge. He can't appoint himself to preside over the trial. And he's made it very clear he wants to appoint himself. He did the break-in trial. Why not do the second one? He's been named Man of the Year. Let's go for a twofer. So this letter comes in and says, worry not, we'll get that to you by January, early February. The time passes. So we go to the next one. Now I gave you a copy of this because I think this is the single most important memo. It's a 2-page memo in everything that I have. I'm going to read it, but you can look at it later. It's dated February 12th, because it's talking about the meeting the day before, February 11th. And it says, I have it in front of me. On Monday, February 11th, I met with Judge Sirica, at which time several matters were covered as we sat alone in the jury room. He again indicated, provided that the indictments came down in time, he would take the case, stating he'd been urged to do so by any number of judges. He expressed his opinion that these indictments should be returned as soon as possible. He also said he was going to henceforth take all guilty pleas himself. That's because Colson pled guilty in the Plumbers case on the condition he be sentenced by Judge Gazelle and not by Judge Sirica, because Judge Gazelle was doing the Plumbers case, and Judge Gazelle is saying, no more. I got you. You got to come to me, because he's rejected other plea deals. In front of him, he rejected the Howard Hunt plea deal, rejected the Cubans plea deal. He said, you got to plead to everything, because he wants to go to trial. We talked about the Vasco case, and he expressed the thought perhaps a sealed indictment might be of some help. Now, you got to know the background. They're seating the jury in New York City on a case called the Vasco case, where John Mitchell and Maurice Stans have been indicted for seeking to influence an SEC investigation of Robert Vasco in exchange for a mere $200,000 contribution. and the jury hasn't been seated. So what Jaworski would have said, I know I said this to you before, but we're going to cover it again. If the indictments come down in Washington, D.C. before the jury is sequestered in New York, Mitchell's lawyers will say that poisoned the jury, so you can't try me in New York. So we got to wait till the jury's sequestered. So Sirica is saying, well, we need that indictment. So why don't you issue a sealed indictment? I can name myself, and we won't poison the well up there. And then he talks about something with regard to his son, and there at the bottom, he says he's been invited to speak by the Texas Bar Association. Now, Leon Jaworski is the past president of the Texas Bar Association. So if you were some yahoo down in Texas and you wanted the famous Judge Sirica to come talk, who would you ask to ask him? You'd ask Jaworski. I think this is very carefully stated to avoid the knowledge or the understanding that it was Jaworski who arranged for the invitation. And of course, Sirica loves it because he's famous. He gets to go. And then the whole second page starts talking about the roadmap. Now remember, we talked about this. Phil Locavara says, if we can't indict Nixon, at least we can take the grand jury information, send it up, and give it to the House. We got to do it in secret. And it's never been done before, but we know we can do it because the Fifth Amendment talks about a presentment or indictment. But if we spring this on Sirica, he's very likely to say, no, you can't do that. So let's go meet with him in advance and inform him of his rights. And here is the paragraph describing that discussion. And Phil Locavara is right. Sirica says, we can't do that. The grand jury material stays with the grand jury, and the House has its own job. And then Jaworski is convincing him, no, you have the power. You know, you're a judge, you're chief judge. And this is his own write-up of what he's doing. But in the end, he prevails. In the last two sentences, he countered by stating he believed he should be informed of the discretion that he could exercise in matters of that kind, and further requested that I have a memo prepared for him that covers this subject. I agreed that this would be done. The special prosecutor, in secret, sidles up to the judge, says this is going to come before you for ruling, but we want to get our side in first because we want to present you with the report and ask you to send it to the Hill. If we get into an argument about whether the grand jury can issue a report and the White House gets involved, we may never see this. We may never have a report because this has never been done before. So let's get our licks in early. And then in I don't have the stuff, but in the notes that are taken by James Vorenberg, it notes that Sirica has approved the format of the roadmap. I mean, so they've actually gone further. There are further discussions. It's all worked out in advance. Okay, so we go to the third memo. This is a memo dated March 1st, confidential file by Jaworski. And we're breaking into halfway through the memo. This is page 3 or page 4. On the morning of March 1st, I met with Judge Sirica in chambers at 10:30. The hearing is at 11. Judge wants a dramatic, newsworthy event, so he's asked the grand jury to come in person to certify that this is the cover-up indictment. This is when the roadmap goes. And they go in secret and they work it out. They rehearse. I'm going to say this, you're going to say that, I'm going to say this. And this is Jaworski. I told Sirica I would ask the court to specially assign the case. That takes it out of rotation so Judge Sirica can assign himself. Because if Jaworski didn't say this, it goes to the calendar committee and it's assigned by random. So Jaworski says, this gets special treatment. And that very afternoon, Sirica appoints himself. And then they rehearse this government briefcase and the roadmap and how that's going to go up to the Hill. So what you've got is documented proof of totally improper meetings, secret meetings between the prosecutors and the judge. You can't then say, oh yes, this judge is fair and impartial and can preside over the trial. I mean, this judge is so dirty and so conflicted, he ought to be removed from the bench for his, the standards, the canons of judicial ethics are so clear. You don't meet with one side without the other side being present. But this was routine for our, Sirica had an open door policy. Okay, we're going to switch now. We're going to talk about something else that's not an ex parte meeting, but is proof positive of political or politicized indictments. What you want when the prosecutor is really bearing down on one side, you pray for an example from the other side in the same time frame where the prosecutor didn't do anything. And that's what I have on the next slide. This is the special prosecutor's treatment of Chuck Colson versus Bill Bittman. Now, Chuck Colson was one of Nixon's strongest advocates. He said, I'd run over my grandmother if it would help Nixon get reelected. He's a notorious Nixon advocate, but he had only minor involvement in the cover-up. Okay? Bill Bittman, who's a Democrat, was counsel to Howard Hunt. He got the money, what we'll call the hush money. There's arguments over what it was, but he presented the demands, he got the money, he spread the money amongst the other lawyers, and he withheld evidence of Hunt's blackmail. Hunt wrote a memo saying, if you guys don't pay up, I'm going to start revealing stuff. And then he got a meeting instead, so the memo was never put forward, but Hunt sat on the memo during all the investigations. So Hunt's dirty as hell. But Hunt is a Democratic icon. He did two things that distinguished himself in the previous administration. He secured the other conviction of Jimmy Hoffa. This is big stuff. And the other thing he did was he prosecuted the Bobby Baker case. Now, Bobby Baker was Secretary of the Senate when Lyndon Johnson was Majority Leader. Lyndon was his boss. Robert Kennedy didn't like Lyndon as Vice President and had triggered an investigation into Bobby Baker. That's why the Department of Justice was covering down on Bobby Baker, which would splash on Lyndon, and his brother could pick a new Veep. Maybe not Bobby, but a new Veep. But Jack went and got shot. So now Lyndon's president. And Robert Kennedy is no longer Attorney General. And they still got to prosecute Bobby Baker, but Bill Bittman does it with such skill that Lyndon Johnson's name never comes up. And that's talent, because Johnson was his boss. This whole time he was taking bribes and giving orders and everything else, dirty as can be. Leon Jaworski is a Johnson protege. So he doesn't want Bittman to get splashed. Bittman is one of his favorite guys. There's an indictment meeting, this is the third bullet, on January 31st, 1974. There's two people taking notes. There's the recorder taking the notes, who's going to be indicted and what's said, and there's the James Vorenberg set that he's going to use to write their report. And up comes Colson. There are others, but the task force, the Watergate task force comes in, does their presentation. They're line attorneys. There are 5 or 6 of them. And then the staff attorneys review and decide whether they're going to agree with that indictment. So they ask Rick Benvenisti, who's on that CNN panel apparently last night. He's the deputy head of the Watergate task force. What are the chances for conviction? He says at best 50-50. Okay? He's not that involved. The rules for Department of Justice in bringing an indictment require the prosecutors have a high degree of confidence that a jury, knowing everything they know, would convict. Now, if you're flipping a coin, it's 50-50. you don't have a high degree of confidence one way or the other. It just, you can't lawyer around this. So this is discussed, and Jaworski says, and it's in the notes, I'm familiar with the facts. I've met with Colson and his lawyer, and I'm willing to sign the indictment because it'll never come to trial. Colson is so scared he'll work out a plea deal with us. So we don't really have to prove the case in the first place. The other set of notes, this is the Vorenberg set, he has Jaworski saying, I know the case is weak, but I'd like to nail Colson. Okay? I mean, he's a flamboyant Nixon supporter. Why not shaft him? You know, we got the right. We're prosecutors. So then up comes Bill Bittman. And Bill is dirty as a person can be. There's 22 boxes of investigatory information on Bittman. Unanimous recommendation of the task force. Jaworski won't do it. He says he's being a good defense lawyer. And the poor person presenting the case is just getting, it happened to be Jill Volner, she's just getting her head stuffed in. Jaworski says, you'd never make a good defense lawyer. This is what defense lawyers do. And he's just done the opposite to Colson. So they don't indict Bittman. And the next day, Phil Lacavara, who's associate counsel from the Solicitor General's office, a man with some integrity, writes a 2-page memo to Jaworski and says, we can't do this. We can't do this. The case at best is 50-50. Those are not our requirements. We told Colson and his people, we announced publicly, we were adhering to the DOJ standard. And it takes him a while to say it, but every person in that room didn't want to indict Colson except for you. I happen to have the memo. You can't read it on the screen, but it's short and sweet. And it ends. I've discussed this memo with Peter Crindler. He was taking the notes, who was present at the meeting on Colson and with his attorney, and he asked that I mention he concurs. Henry Ruth, who's deputy, has also recommended that for similar reasons Colson should not be indicted. Everybody in the room except Jaworski. So they had a second meeting. I don't have the notes from the second meeting, but Vorenberg's notes at the second meeting in all caps in a bracket say collect memo. Let me tell you, they did not want this memo floating around. I mean, this is outrageous. And they got every copy back except the one Jaworski took with him when he left office. So there it is, black and white, incredible difference between Colson, the Republican, and Bill Bittman, the Democrat. And we're going to do something else with Colson because this just came out, and I'm still outraged over this. There's a commentator on MSNBC, a lawyer named Nick Ackerman, who was a young lawyer in the Watergate office. Maybe you see him. I don't watch MSNBC. He graduated from Harvard in 1972, and he joins the prosecutor's staff in May of '73. So he's done something for a year, but he's not a prosecutor. He's just a kid. I was just a kid. Okay, we were all kids. Lots of us were kids. And he spent 2 years, his entire time, on the special prosecutor's staff, investigating and trying to prosecute Chuck Colson for the May 3rd incident. Hoover died. Okay, you aren't supposed to read this quite yet. Came up too soon. J. Edgar Hoover dies. He lies in state in the Capitol. And on that day, there was going to be an anti-Vietnam War demonstration, because it was Hoover. And the Republicans were gathering a counter demonstration. And they met, and there was a clash, and the police arrested 3 Cubans who were trying to save the American flag from the anti-war people. Okay? So what they decide is maybe Colson's behind this and we can get Colson on this. And they assign this young kid, Nick Ackerman, to do it. And it doesn't quite work out, but he spends 2 years working on it and comes up with nothing. So what does he do? He writes a memo. He writes a 18-page memo documenting how hard he tried. Okay? And as with other stuff that pops out, the purpose of the memo was not to document the prosecutorial abuse. The purpose of the memo was to say, look how hard I tried. You know, I mean, I didn't get famous. My name's not in the paper, but I tried. I didn't come across this memo. He appeared on NBC, I think the 45th anniversary of something last year, discussing this memo. Now, if the memo had come from the National Archives, a bunch of names would be redacted because they're still alive and nobody got indicted. There's not a single redaction in this memo, this version, because it's Nick's memo. It's Nick's copy that he leaked to talk about how great he was. And you read it, and it's the scariest document that I've ever come across. And he says an extensive investigation was conducted by this office on this assault. The initial decision was made in early July by Phil Heyman, who was working with Bill Merrill on the Plumbers Task Force. They were looking for stuff to do. They wanted to bag Colson. Heyman's decision to investigate this incident was based primarily on the alleged involvement of Chuck Colson. I'm skipping a whole bunch of stuff. It subsequently developed Colson became the prime target of this investigation. As will be explained, this is the second paragraph. As will be explained in the course of this report, the evidence ultimately developed by this investigation would not be sufficient to indict Colson for crimes relating to the assault, but would have been sufficient to indict him for perjury if he had denied knowledge of this incident under oath in the grand jury. Now, this is, if you study this like I do, this is reminiscent of George Frampton's leap of faith in the prosecutorial memo on Richard Nixon. All the grand jury would have to do is to assume one little fact, that Nixon had ordered the payoff be made to on Hunt's blackmail, and then they could have found him guilty of participating in the cover-up. This says the exact same thing. We don't have enough evidence to indict him, but if he were to lie in front of the grand jury, we could indict him for perjury. Well, no kidding. If you were to lie in front of the grand jury about the weather outside, we could indict you for perjury. This is a nonsensical statement, typical of 1972 graduates of Harvard Law School, because I graduated in 1969 and the law school went down from there. Okay? 18 pages. And then he starts describing how hard they tried. They started interviewing the demonstrators, then the counter-demonstrators, then the D.C. police, then the people at the Republican National Committee, then people on the White House staff, trying to get to Colson. Unrelenting search for Colson. They concocted an hypothesis. I have some time. I'm going to read it. This is their hypothesis. Well, let me start above. Beginning in September, it became more structured, and Horowitz and I developed a working hypothesis. The assault and the counter-demonstration, that's the patriot part, not the anti-war part, were both instigated by Colson for the purpose of disgracing Daniel Ellsberg. This hypothesis was formulated from two factors. First, Colson's memorandum on Ellsberg says we got to do something about him. And second, this particular demonstration brought together two very explosive elements, the anti-war and the patriots, so you might have assumed there was going to be trouble. On the basis of this hypothesis, it was decided to interview members of Colson's staff, re-election committee employees, counter-demonstrators whose knowledge might be important. The CREEP employees included top officials, their assistants, their secretaries, participants in the counter-demonstration. We got people from the D.C. police had observers, the FBI had observers. We interviewed all of them, and then we started to focus on a couple of people. from the Republican National Committee, Ken Ritz, and Karl Rove. Our friend Karl was a kid at the time in charge of students for Nixon. So his name is misspelled here, but his name pops up every once in a while. He's lucky he escapes. In September, Karl Rove, an employee of the RNC and one of the counter-demonstrators, revealed that John Lofton, editor of Monday, that's a Republican magazine, had led the counter-demonstrations, that John Lofton had led the counter-demonstrations with a bullhorn. Well, fancy that. So we went and put him under oath and put him in front of the grand jury to find out what's going on. And then we started focusing on two members of Colson's staff, Bill Radigan and Dick Howard. And what we got Radigan on was we decided he'd actually perjured himself. But he perjured himself about a lawful act, which made it a little bit hard to prosecute. But man, we leaned hard on him. We leaned because we wanted him to flip and say Colson was responsible for planning not the counter-demonstration, but the assault that followed. And we did the same thing with Dick Howard. I mean, we leaned on him and we told him, you better get a lawyer. We're going to indict him. We told him we were going to indict him. But Radigan's attorney was told we were contemplating indicting his client for perjury, although no decision had been reached as to whether a viable case could be brought. Ackerman and Horowitz decided that the threat of a prosecution might be enough leverage to bring Radigan around as a government witness, and they go after Dick Howard. I'm almost through. At approximately the same period of time we were dealing with Howard, Colson began negotiating for a plea deal in the Fielding case. This plea bargain was struck on May 1st. During the negotiations, Colson's attorney commented that he heard we were putting pressure on Dick Howard and that Colson was not going to let his subordinates take the rap for him in the way others in the Nixon White House staff have done. Moreover, just before Colson's deal with this office was finalized, Shapiro asked whether Howard would still be indicted. Merrill said that Howard's disposition would stand on its own merits. Howard was not indicted for perjury simply because the evidence was not substantive enough to convict. With respect to the possible 610 violations, these are political pamphlets without naming an author. We basically lost, even though these may have constituted violations, we basically lost all interest in Howard after Colson pled. Okay? So they are hammering his staff to get them to flip on Colson because they want Colson. Remember, we started with Attorney General Robert Jackson's admonition. You can't go after people, you have to go after crimes. This is an 18-page document that's the opposite. This is the last paragraph. Although it's quite clear Colson lied when he testified to the grand jury and that immunity from perjury committed when testifying after his plea was specifically excluded, we could have won. The problem with a perjury prosecution are twofold. First, there's no proof of Colson's motive to lie, although it may reasonably conjectured that Colson lied to protect Dick Howard, his staff guy, and from indictment, and Richard Nixon from impeachment. Of course, we all know that. There's no way to prove it. Secondly, there's still no clear way to link Colson to the assault, which is muddled by his efforts to organize a lawful counter-demonstration. This melding of the counter-demonstration and the assault had been a problem throughout this investigation in charging anybody with a crime. 2 years spent on this. They came up empty. But he still practices law, and in his bio on his law firm in New York, Nick appears regularly on MSNBC concerning topical national issues, including the FBI's ongoing investigation into Russian tampering. It goes back to his original work. Assistant Special Prosecutor with the Watergate Special Prosecution Force from 73 to 75. True. Conducted grand jury investigations into misuse of federal agencies. Could have fooled me. This is all he did. There's no federal agency involved. And other allegations of criminal conduct related to the break-in at the DNC. This has nothing to do with the break-in. This has everything to do with Chuck Colson. Examined all of the principals in the Watergate scandal before the various Watergate grand juries. A small exaggeration. This is a kid, 1 year out of Harvard Law School, devoting 2 years to trying to get the goods on Chuck Colson on some marginal issue. But you read his write-up, man, he was right there. He's like Shepard. He was right there in the middle of it. Okay. Now, remember that keyed off of Hoover. Okay, Hoover lies in state, then Hoover's buried at the Presbyterian Church, big Presbyterian Church in Northwest. And Nixon's going to speak. So I got to clear the speech for substance, because I'm the law and order guy. Okay, the speechwriters write the speech. Small stuff. Everything he says, there's got to be a check mark that this fact was checked. And what he was going to say was, I'm going to ask Congress to name the FBI building then under construction the J. Edgar Hoover building. It's weak, but it's something to say. I knew from prior activity that the President of the United States can name or rename any federal building without restriction. So I conveyed this to the speechwriter and said, look, he can just announce he's naming it. He's the president, he has the authority. Well, because we always want to show you that Jeff was there, that resulted in a letter. So I get a letter yet again from the president. I only have two. I showed you the other one. You did, dear Jeff, I mean, we're close. You did a splendid job on the matter of the naming of the FBI building, and I wanted you to know how much I appreciated your efforts in helping us to honor Director Hoover. Many thanks. Sincerely, the President. Okay. We go from this mess, to the width of the investigation. Remember, the prosecutors announced at their first press conference, they would investigate every allegation made against the Nixon administration. Okay? They have 60 lawyers, 100 people, all of the FBI, all over the IRS. These are quotes from their final report, which they put out in October of 1975. This is a year after Nixon's resigned. And they go through, this is a victory lap, and they talk about Nixon's resigned and they've convicted and imprisoned 24 of my friends, which they did. But look at what else they tried to do and failed. These are fully investigated but found no grounds for prosecution, and I'm just following their page numbers. The lawyer's role, mine, in the White House tape transitions. Any campaign dirty tricks by Democrats? Well, of course they didn't find any by Democrats. The ITT payoffs, the allegations of the ITT payoff on the antitrust suit. The wiretap investigations, those were the 17 NSC wiretaps. The IRS enemy audits, we talked about that. They found no basis for prosecution. The mistreatment of demonstrators, that's this. The 30 pay-to-play investigations of agency decisions, where they would say, look, these people gave money because they wanted a particular regulatory decision. We didn't prove a one. We couldn't find one. Sales of ambassadorships, the Hughes-Rebozo investigation into the loan, I think it's to Nixon's brother. And finally, the National Hispanic Finance Committee investigation, about which I knew nothing. But there's this whole list of we tried, we gave it the real go. We couldn't find anything in these areas. But, you know, if we had 100 people, we could investigate Temple. And we'd come up with more stuff than they came up against the Nixon administration. So this is Maurice Stann's comment after he's been cleared of all the finance investigations. The prosecution force investigated several hundred such accusations through thousands of interviews and subpoenas for thousands of documents, using his own organization, the IRS, the FBI, computerized records from the Ervin Committee, and information from members of Congress. After 2 years of ferreting out the facts, he announced in his final report he could not find evidence adequate to take to court a single instance within this entire range of alleged corrupt practices. That was the surviving sum and substance of all of the alleged financial corruption of the 72 Nixon campaign. Not a single proven case of corrupt action. No favors granted, no contracts awarded, no cases fixed, no ambassadorships sold, no illegal contributions from foreigners, no overseas laundries, no illegal solicitations, no list of companies in trouble with the government, no enemy lists, no fundraising by government officials, no extortion, no coercion, no intentional circumvention of the law in a single instance. That's precisely what the Department of Justice, the special prosecutor, and the courts found. Of course, Maurice Stans had to have his book published privately because nobody wanted to hear that side. He's the one who so famously said, "Where do I go to get my reputation back?" Because every one of these things was featured in the newspapers, to allege is to certify it's true. Then, I don't have time to go into this, Cox was so worried that Sirica was so pro-prosecution that they'd win at the trial and they'd lose on appeal. He had a secret meeting with the chief judge of the appellate court, and he told him that he should stack the deck on the appeals so that the five liberal judges could be sure Sirica was never overturned. There are 12 criminal appeals from Judge Sirica's trials. Every one is heard by the full court en banc from the outset. Remember the words sua sponte en banc. It's on the exam. At the same time, there are 4 criminal appeals from Judge Gazelle. Gazelle's liberal, but competent. He did the Plumbers trial. He did the Chapin perjury trial. None of his appeals are heard out of rotation. It's the traditional 3-judge panel. So the corruption, the prosecutorial and judicial abuse even reached the D.C. Circuit Court. So we say, why haven't we heard? Why is Shepard telling us this? Maybe we believe you, maybe not, but if you're so smart, why aren't you rich? Why can't we find this someplace else? Okay? Well, one, there was liberal commentary. It just got no coverage. Renata Adler and Richard Harris and George Higgins. The ACLU filed an amicus brief saying you really should. The defendants have asked for a hearing on possible ex parte meetings with Sirica. You owe them that. And of course, the D.C. Circuit didn't want to have anything to do with that. Bazart prepared questions for John Dean in the Ervin Committee. The Republicans wouldn't touch them. Bazart prepared a 50-page defense of Nixon's conduct based on the tapes. We released it with the tapes. Not a single article. The stuff was there, it just didn't get coverage. Why? Well, there was a monolithic Eastern liberal establishment press. There were only 3 networks, NBC, CBS, and ABC. They're all headquartered within a 6-block area in Midtown Manhattan. They all thought the same. The 2 dominant newspapers were the New York Times, you probably read it, I don't, and the Washington Post, which wasn't that big, but everybody in Washington reads the Post. It structures the debate for that day. So you may not get it in Utah, but my heavens, it's influential in Washington, D.C. And there were 2 weekly news magazines, Newsweek and Time. They were supposed to provide the in-depth analysis, and they did. It was just all anti-Nixon. So Nixon's isolation and his lame duck status meant essentially he had no defenders outside of the White House compound itself. The Ervin Committee Republicans chose not to fight. Lowell Weicker joined with the express intent of sinking Nixon, and Howard Baker wanted to run for president, so he wasn't going to stand in the way. Why get in front of a freight train? If you stood up to defend Nixon, the press would be all over you. Where do your kids go to school? What did your wife order for breakfast? There was no place to hide, so all the defenders just took a step back. There was no Fox News, no talk radio, no podcast, no alternate media at all. And Phil Locavara gives an interview. I mentioned this before. After Nixon's gone, and he was asked to speculate on why Nixon and nobody else. And he said, well, unlike other presidents, Nixon didn't have the level of popularity to fall back on when he got in trouble. So when he needed friends weren't available. And then you get the fact that these 2 key sets of files were improperly removed. Jaworski takes his back to Texas, and Jim Vorenberg takes his back to Harvard, and this is where the secrets were. Now, Woodward could have known. I showed you his notes. It's phenomenal. It's embarrassing that he could have, and this all could have come out a long time ago when I was a young man. Okay. This is Bob Bork. Bob Bork comes into the Saturday Night Massacre, okay? He writes a book called Saving Justice, Watergate, the Saturday Night Massacre, and Other Adventures of a Solicitor General. It's published in 2013. It is published posthumously right after he dies. And he talks about what it was like to be Solicitor General and what it was like to survive the Saturday Night Massacre. Now, I was reading it yesterday. I wanted to read, I read it before. I wanted to read you the whole book because his take is so different from what you were told. Here's what he says as SG. I argued the statutory case, this is on impoundment, the issue of impoundment, and got my hat handed to me. The court was very unfriendly to impoundment, particularly because Richard Nixon was president. As I slowly realized, the unspoken rule was that Nixon was not going to win any cases. That's not to say the office of the presidency did not win any cases. It certainly did. But the closer any particular case got to Richard Nixon, the person, the quicker it was, oh, there's a typo, the quicker it was rejected. Okay? This is the Solicitor General saying these courts are all biased as they can be against Nixon too. And then he goes on to talk about what it was like to be acting Attorney General. Remember, I was the guy who went over to see him after the Saturday Night Massacre to ask for some legal help. And he really wasn't very friendly. He was not outgoing and meeting me halfway. He just, okay. Throughout the matter, I was surprised and disappointed at the failure of so many lawyers to act like lawyers, prone to complimenting each other as specialists in process. Many lawyers demonstrated during the week after the massacre and throughout the Watergate affair how easy it is to let process take a backseat to preferred political results. For those who found their liberal identity before embarking on a career as a lawyer, they regarded Nixon as ipso facto outside the law. So long as lawyers persist in castigating Nixon, so long would they forfeit the respect due a learned profession. I mean, he's just saying the same thing that Morris Stans was saying, that I was saying, that even the bar, the judges and the other lawyers are just, Nixon won't win. It's just not going to happen. He's an outsider. Okay, I did 2 books. I just put them up. The first book came out in 2008. It talks about the politics behind the Watergate affair. I have a second book, came out in 2015 when all of these secret memos were uncovered about the specific allegations of impropriety. And then we get to a quick summation. The Watergate convictions are accompanied by an astonishing lack of due process. And down the next bold part, Nixon was driven from office by secretly conveyed but erroneous accusations of personal impropriety. We developed that in earlier weeks. This is the last slide. What's going on today? Well, the files resurfaced. I've published 2 books. And down at number 4, there's pending legal challenges. There's this petition that I have in front of the D.C. court to unseal the transcripts of what the prosecutors told the grand jurors to get them to name Nixon an unindicted co-conspirator and to move the roadmap up to the Hill. And there's a fight over whether grand jury secrecy rules prevent that, and the Department of Justice erroneously thinks they do. Just last week, there was a decision at the circuit that upheld grand jury secrecy. And they said, well, the Nixon decision to transfer that stuff to the Hill, that was in error. Oh, well, thank you. And while they didn't say it, the release of Nixon's grand jury testimony in 2011, that had to be in error too. Now, this is going to keep being appealed because a couple of other circuits have said, no, a judge can release for historic purposes, the Second Circuit in particular. So it may end up in front of the Supreme Court. I want to get back to the judge hearing my petition, current chief judge. Say, wait, I'm not talking about disclosing witness testimony. I understand that. I'm talking about disclosing prosecutorial representations because I think they'll show prosecutorial abuse. So we're not talking about witnesses, and I'm talking about abuse. You should do it my way. We'll see. This has been fun. I took up 10 minutes of your time. We now switch and we go to Q&A. Remember, we have a camera, so Ken.
Going back to the beginning, the break-in. Burglary is not a federal crime. It's a state crime.
Yes.
What was the trigger at that point that moved it from essentially state jurisdiction to federal jurisdiction?
Well, the people who were involved, James McCord was an employee of the re-election committee, and it soon developed so that Liddy was too, and Hunt. But what you say is true. There's no federal burglary statute. Los Angeles County indicted them for burglary, and that would normally be where the case was. But this case had political ramifications, and from the outset, there was a full court press by the Department of Justice, not surprisingly, to find out what the heck had been going on. And it just got worse and worse. But in the beginning, it was the career prosecutors. And that would have been okay. It's when the cover-up collapsed, it should have collapsed. And we brought in highly partisan, specially recruited people to take the investigation in an entirely new direction. They postponed the indictments for 10 months, and they launched investigations into every aspect of the Nixon presidency. That's where it went off the rails, but it's our fault, or in the bigger sense, because John Dean was running this cover-up. I mean, it just made it much, much worse.
Can you repeat the question when?
Yeah, the question was, how come there was a federal prosecution when there's no federal burglary statute? Burglary, interestingly, burglary is a local crime. They always let the locals prosecute those sorts of things. Ma'am?
If a special prosecutor per se is a function of being initiated during the Nixon administration, why then is it not possible, or is it possible, to have that eradicated as allowable because it happened once?
How did the special prosecutor come about? Why can't we prevent it in the future? They're so abusive. There hadn't been a special prosecutor for 50 years, since Teapot Dome. But as a condition of confirming Elliot Richardson, the Senate Judiciary demanded the appointment. Now, Nixon had offered, when he announced Richardson as his nominee, that he could appoint a special supervising prosecutor. He was picturing one guy to make the decisions on what the Department of Justice recommended and to give Richardson some help, because there were going to be Republicans going to jail. Richardson didn't want to be Attorney General and wanted to run for president, happily abandoned all responsibility, and the original budget for the special prosecutor was 100 people. The powers that be thought it was so much fun to have special prosecutors that one of the Watergate reforms is the Ethics in Government Act that sets up the independent prosecutor, which was, Renata Adler was talking about this absolute aberration that mixes up the judiciary with the Congress with the executive. And it was in effect for 25 years. That was how they prosecuted the Iran-Contra affair against Reagan. And it was jolly fun until it was used against Democrats with Bill Clinton. And then they decided, this isn't fun at all, let's let the thing lapse. So what it lapsed to was the ability within the Department of Justice to appoint a prosecutor who would report to the deputy or to the Attorney General. So you could have a degree of independence, but still under the overall rubric and rules and supervision of the Attorney General. That was Patrick Fitzgerald going against Bush II, the Valerie Plame affair. That was this prosecution. Jeff Sessions recused himself, so it went down to Rod Rosenstein. I don't think we could come up with a better answer than that. There are going to be situations where you need and deserve a special prosecutor. We'll talk about this next week. I'm not sure this was one of them, because you get such abuse. I mean, if power corrupts, and the ability to prosecute, to ruin people's lives is nothing short of incredible. And I read you that quote from Judge Silberman, who was Deputy Attorney General as Watergate wound down, who said, one of the difficulties is the special prosecutor is evaluated based on who he bags. And he's got to justify his budget, so he just keeps looking and keeps looking. We'll talk about it next week, but I'm far over. When did Mueller conclude there was no Russian collusion? Was it a year into it? Was it 2? Did he just think of it the day before he offered his report? But that's pretty key if you were the object of his investigations. Sir. You were scratching your head. Sir.
I'd like to learn more about your petition. Where is it sitting right now? What level of the courts?
The district court, because I filed it back in 2011, a little slow, when the other side filed to release Richard Nixon's. And I said, okay, turnabout's fair play. I'd like to see some of our side come out. And it kind of sits because I don't know what I'm doing. These other 3 lawyers who enlivened it about 2 months ago, they said this is a great precedent for shafting Trump. We'll take the grand jury stuff. Grand jury's got to know stuff about Trump. We'll use the Nixon precedent to move it up to the House Judiciary Committee. And that's sitting there also. We'll see where it goes.
Has anybody answered it yet?
Well, the judge originally said, your request is too broad. I'll give you the right to narrow it. I narrowed it, and everybody went to sleep. I was doing my other book, so I didn't do anything. When these new guys filed, I sent a note down saying, I've been here for 5 years, and the judge ruled on, initially, the new chief judge ruled that whatever portions of the roadmap had become public other ways, she wanted to see, and she wanted to be informed of who would be hurt if she revealed the rest of it. And then there's this case in the D.C. Circuit that was just decided last week. She said we're going to hold everything in abeyance, pending the resolution of the McKeefer case. I got to go on. We can talk. Sir.
Is there a difference in the propriety or impropriety of the prosecutor's meeting with the judge in his role overseeing the grand jury as opposed to overseeing actual trial and the merits?
Well, you could, the question is, could you defend Sirica's meetings? I'll add to your question. Could you defend Sirica's ex parte meetings because he was the supervising judge of the grand juries at the time? So, and there wasn't lawyers on the other side. So could you say, well, that was his job as judge? I would hate to take that on appeal because the rule is we have to avoid even the appearance of impropriety. Now, I don't mind if then, as I think today, the chief judge supervises the grand juries in Washington, D.C. But then that chief judge can't sit at trial. That's the problem. He was in one role as judge watching the grand juries and maybe working stuff out, but this was stuff that was going to come before him for ruling. I mean, that's way, way over the line. And they knew who the lawyers were on the other side. This wasn't, gee, we didn't know who we were going to indict. You could say those words. Okay, he was supervising. As Judge Sirica himself said on the appeal, he said, everything I did as a federal judge, so you can't question me. That would be hard to take to an objective court on appeal. I would not want to argue that side. We still have 10 minutes, sir.
The Constitution sets up impeachment as both sort of a political and a criminal procedure. I mean, it's got elements of both in it. Do you think that what Nixon and the break-in evolved as evidence of misbehavior rose to the level of impeachment? Had the impeachment process moved forward, and would it still have been impeachable if the investigation had not taken place by Sirica and the special counsel?
The question has to do with the House's ability to impeach, and the assertion is impeachment is both political and criminal. if Sirica hadn't cheated, could they still have impeached Nixon?
And convicted.
Well,
Impeached and then convicted
yeah.
in the Senate.
I have to take issue with your base assumption. There's no criminal aspect of impeachment. There's a statement that in order to impeach, we must find you guilty of high crimes and misdemeanors, but it's not defined. And those can be anything the House says they are. The House cannot imprison. If they impeached Richard Nixon, which they were gonna, if they impeached Richard Nixon, they couldn't have imprisoned him. If he'd been convicted by the Senate, they could not have imprisoned him. That's why the prosecutors wanted to indict him after he resigned, and the Ford pardon intervened, and then because they were in full galloping regalia, they wanted to challenge the authority of Ford to pardon him. And that's one of the funnier memos in the file. We may see that. We'll talk about it next week. I think it's without question that Nixon would have been impeached. I would add that they hid from us the fact the prosecutor was giving grand jury information to John Doerr, improper, and that Doerr was saying in secret Nixon had personally approved the payment of blackmail. In their dilemma, it really gets fun when you put yourself in their shoes. They had no witness who could testify to that. They had Dean saying he wants money, and the money paid. They had the guy who paid the money. But they couldn't put someone on the stand to say, and Dick told me, Bob Holloman, I want that money paid. They didn't have anybody. So how do you get that case presented to a jury? How do you get that case presented to the members of the House Judiciary Committee? And they couldn't. That's why they did it in secret. And we didn't know. We could have disproved it. But we didn't know it was being made. It's just another one of those what if. What if Nixon had a defender on the Ervin Committee? What if they really cross-examined John Dean? I mean, Bizarre spent weeks preparing the reaction to John Dean. It was tossed out.
Well, you would assume that Dean would have been cross-examined had it gone to the Senate.
Well, what if? One of the difficulties that you got to factor in, two, the rearming of the staff, where both sides lost institutional memory, and Nixon fading in power and influence as a lame duck. Why would you stand up in front of the freight train? Then there's just no percentage. Last question? Ma'am.
Wondering, has Tricia Cox or Julie Eisenhower reached out to you at all?
Well, I know them both. I didn't know them when I was on the staff. There was a very, very firm Chinese wall between the staff and the family that you'd be fired if you attempted to cross. They're aware of my work, okay? The Nixon Foundation, which I'm not an officer or a director. The Nixon Foundation has a bifurcated view of Watergate. Half the people think Nixon will never get a fair shake if we don't attack brutally. Shepard's done all the work, charge. And the other half says we're never going to win that battle. Public opinion is hardened. My book says one of the sad lessons of history is once people have been bamboozled, they don't want to be convinced of the other side. We're wasting our time and money. We'd be better to talk about Nixon's accomplishments. And honestly, my best friends, 40 years, we served on the White House staff together, really good friends. I'll spend Easter with one, I'm having lunch with the other on Tuesday. They're on opposite sides. And I don't blame them. I understand the dilemma. I'm I'm a dangerous friend. And what I have, because it's so hard to explain, we've got 18 hours, you know, and I don't think I don't think I've made the case I hoped to make when I started. You're very kind. We will see you next week. Remember, next week we talk current events. So read the New York Times. Watch the TVs.